Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone and welcome back to another live stream with me, Gisela K. This is Grizzly True Crime. Today we are back to discuss the Delphi case. I just wanted to discuss this new motion with you that the state has filed because I find it absolutely crazy. And I might be wrong because I'm not an attorney, but when I read this, I'm like, the state is asking for what? Like for certain terms and, phrases to be banned from the trial. The defense is not allowed to talk about certain things, which means they're not allowed to introduce any reasonable doubt. And in my opinion, very plausible, reasonable doubt exists in this case, right? I know there's lots of opinions in this case. It's a little bit divided actually at the moment. You're on one side or the other is what it seems like. I always like to be, more on the fence and offer neutral, unbiased coverage. But in this case, it's impossible to do so because of everything that's happening. You're going to fall on one side or the other, right? And I'm just shocked by what the state and the judge are doing, in my opinion, in this case, right? So I am aware that the defense, recently we looked at what does the defense want thrown out before the trial and what does the state want thrown out, right? So the state was going after Todd Click's testimony and anything that he had to say, going after Todd Click's credibility and all sorts of things. Okay, and he's one of the guys that was investigating the Odinist angle of this crime. So that was already weird. Let me just quickly remind you what the defense wants thrown out. Before I do that, welcome to all my moderators. Thank you so much for everything you do. Welcome to all my patrons, members, subscribers, any locals in chat, anyone new over here. Thank you so much for being here. So remember in the last documents we looked at, okay, in this Delphi case, if you know nothing about this case, please check out the description box. There's always a little case background write-up for you, and there is an extensive playlist for you to catch up if you want timelines, presentations, map time, and wow, like a large amount of documents, because I've been covering this, all along the way, and it's become very document heavy, of course. I mean, it generally would, but in this case particularly, it's like, wow, what a mess, right? What a mess. Objection cake, very well said. Grizzlies are on Abby and Libby's side. My concern with this case is if there's not going to be a fair trial, there will not be true justice. That's not how it works. Everything that I'm seeing that the judge and the state's doing in this case is just completely not in line with what I have observed the American Constitution to be about. And it just seems like they're not really following protocol. They're kind of just doing whatever they want, and the world is watching. Everybody could see. And I just think it's absolutely crazy. I'm like, whoa, when all along, you just think things can't possibly get worse. They can't get worse. And I've said in my last stream, the thing I'm worried about now is that the judge still has to rule on the contemptuous conduct hearing from March 18th. Can you imagine if she just rules, yeah, you know what? I agree, McClelland, prosecutor, that was contemptuous conduct. She could literally any day now, okay? She has to decide sometime, I think it was in the first week of May. The trial is supposed to start on May 13th. If Judge Gull decides in the first week of May, you know what? Yeah, no, that was contemptuous conduct. I'm going to throw these attorneys off again. Well, that's going to severely delay the trial, of course. It'll change everything. Just who knows? I don't even know. I don't know in my gut. I'm just not sure if it's going to be a trial on May 13th. And if it is, I don't have any confidence that it's going to be a fair trial, especially based on what we're seeing here. Before I read this, I want to offer some balance and just say that the defense did in their last motions file for sanctions, and they wanted thrown out of the trial, Richard Allen's work records, mental health records, multiple confessions that they say he made, that the state says he made. They want that thrown out, from self-incriminating statements from his police interview to confessions he allegedly made while in the prison, all sorts of things. They also initially wanted the search warrant results thrown out, as well as all cell phone data from Libby German's phone. So, I mean, one could look at that and say, why would the defense want all that out? But they did explain why. And it's because there's been very little like chain of custody, proper protocol, a solid investigation. There's been 70 days worth of interviews lost, including with the people that now the state says you may not talk about them, you may not mention them. You may not mention them, but you people lost the interviews. But now the defense may now not mention them at this trial. So this has not been granted yet. I say yet because Judge Gull likes to, it's just how we see it, how we observe it, right? Just a commentator from the outside looking in. Judge Gull just like grants whatever McClelland asked for very quickly, within the hour just about, and then anything the defense asked for is like months of delay or just denied, right? So I don't know, I think that Judge Gull might actually grant this insane motion in limine, in my opinion, based on the pattern we've seen. Albo's mom, thank you for 29 months of membership. I think she might grant it. If she does, I'll be back, and again, I'll be going, oh my word. Then we're going to need some lawyer friends to come and join us here. Tell us what's going on here. So, Retro says, no way. Well, they want Libby's phone data thrown out, not Abby's. So, Libby German's phone. Anyway, that was from the defense. Now, let's look at what this motion says. It's 4 pages long, and it's interesting and shocking at the same time. State of Indiana versus Richard M. Allen. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully requests that the court enter an order required that the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening argument, presentation of evidence, and closing argument. So the entire trial. Not just during jury selection or during cross-examination or anything like that. They're like, throughout the entire trial, the defense is to refrain from mentioning any of the following things, right? So they say, and closing argument, any and all references to the following, either directly or indirectly. Now, here's what they want. And the more I read this, I'm like, what? Okay, so number 1, any comments about counsel for the state that constitutes a personal attack on the attorney for the state, or comments on the role of the state's attorney. There were some cases cited there. 2, any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. All right. For instance, the defense counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers or any of his own witnesses. Okay, so if the state wants to call up some shady police officers, that's going to be okay, and the defense is not allowed to ask any questions. Number 3, any innuendo or inference that is not supported by admissible evidence. Here, they go on to say, let's go on, wait, it's just citing cases again. They say attorney cannot assert unsubstantiated allegations on collateral matters. 4, any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issue in the case. Right. Interesting choice of words, because I think if anyone's trying to indoctrinate the jury and like, right, Richard Allen's guilty, right, that's the state. Listen, defense, you're not allowed to bring in any reasonable doubt, okay? That's it. So no wonder McClelland was so worried about the defense's other strategy, which seems to be, their one strategy would be the Odinist angle, third-party involvement, other groups, and stuff like that. And the other strategy seems to be mental health related, that is when he's confessing his mental health is not quite right, all that, right, which I think holds some weight. However, no wonder McClelland was, attacking the confession, mental health type of strategy. Okay, and once Richard Allen's mental health records and all sorts of things, and was expressing concern because he knew that he's going to try to silence them on the other theory. Okay. Sweet dude Shibby says, admissible evidence that was lost? Yeah, that. They're like, you may not speak about that evidence that we lost of the people that we were initially interested in as suspects. Right, okay, which they now say, they're not suspects. Right, you were just at their house. The whole FBI, at one guy's house, the other guy being interviewed, lots of people having their interviews recorded, and then lost. Those were just lost. Like, okay. So any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issues in this case. So don't tell the jury that this case is botched and absolutely rocky at this point, okay? Don't make me look insecure in front of the jury, is what, what it sounds like McClelland is saying there. Don't you people humiliate me, okay? I've got a strong case here. It doesn't sound like you do. Does this sound like the state has confidence in the case, or a strong case? Because to me, it really just doesn't, right? All Eyes on Delphi says this is what it looks like when a prosecutor wants to close a case they didn't actually solve. That's what I'm thinking. So they say, number 5, any attempt during voir dire to have the jury prejudge the credibility of a witness. Don't you bring up shady witnesses, okay? You don't tell the jury they mustn't know anything. Wow. Number 6, any hypothetical questions that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705. Number 7, and here's the one that had my jaw on the floor. Any attempt, okay, to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice. Confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Do you mean like the runes, the sticks, the people you interviewed and you lost their interviews? Some of those guys mimicking the crime scene in artwork that they posted on their Facebook. I don't know. Things like that are not allowed to be talked about. I'm just like, how insecure is this prosecutor? Honestly, it makes me really worried. And the fact that it seems like, I'm just going to say it in layman's terms, it's almost like the judge is like mommying him, like, don't worry, it's going to be okay, baby boy, you're going to do just fine. And he's like, I don't want them to say any of these words. Okay, so they say before any such evidence, so he says, okay, just to spoiler here for the next point, look there, we're going to read through all the things that they're not allowed to say. But before any such evidence may be permitted, the defense must show a connection. Now, if they're going to show Todd Click's investigative materials as the connection, they're also not allowed to do that, okay? They're not allowed to. Like, what? Wow. So they say further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or a theory. A theory that the FBI investigated. A theory that 3 investigators were very busy with on that angle, of which one of the investigators was murdered by a correctional officer. I mean, wow. It's just like, right? Purple Amaryllis says FBI BAU report on crime scene. We want that report. We want it. So, I know what you're referring to, and it's very, very interesting indeed. Now, do I say Gazelle? Like Gazelle? When people call me Gazelle, I'm always like, it's Gisela. But is your name like Giselle? Gazelle CD? I never heard of a prosecutor ask for so much. He's asking the judge to hand him the trial. And she probably will. Like, here you go, baby boy. Here's your trial. Like, yeah. Objection Cake says no toddy allowed. There will be no toddy click testimony. So here he says further, it must be a direct. So it must be a direct, solid proof investigation, basically, a connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory, right? And then he says the state requests such order in limine to include but not be limited to. So this is not even the worst of it. To include but not be limited to. So you can imagine anytime the defense is going to open their mouth, objection. And then it will be sustained, right? From the state. If the state is like, objection, we said they can't mention that. Sustained. I mean, they absolutely gagged in this trial. No wonder it's only a 3-week trial, including jury selection. They want to basically be like, we're done here. Solved. I just don't believe that. Right? And people can call me whatever they want, conspiracy theorist, biased, I don't know, whatever the hell. I don't care. Because in this case, I can smell corruption a mile away. This is just not right. Even if the argument was, Richard Allen did it. Okay, but they botched the case. So that's on them. Okay? Then that's on them. They have to then deal with the consequences of botching the case and doing this kind of crap. Like, what is this? The state requests such an order in limine to include but not be limited to the following. Odinism. These are banned words, okay? Naughty words for the trial. Odinism, cult or ritualistic killing. Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams. Those are all the Odinist dudes, allegedly, according to the Franks Memorandum. And what's interesting about that is Elvis Fields, of course, he's one of them that confessed. And I say it like that because he's like, if you find my spit on one of the girls, okay, and I can explain it away, am I still in trouble? And people just write that off as, don't worry, like this guy, shame, he is mentally incapacitated, so we can't take what he says for real. But I mean, his sisters had polygraph tests and everything. It's ridiculous. Sorry if you hear the door. Mr. Grizzly just came home from a jog, so hi to Mr. Grizzly and the cats. So look at all these words, right? They can't mention any of those guys. Cult or ritualistic killing, Odinism, Kegan Klein, Jerry Klein, or Ron Logan. They can't mention Ron Logan? Even though the victims were found on Ron Logan's property? Wow. What are they allowed to talk about then? What is the defense allowed to say? Right? Mallory Beaver says, did the judge actually approve this already? Not yet. Not yet. Let me just quickly see here. I'm just going to make a hashtag Delphi because she normally approves this kind of stuff quite quickly. Okay, so must watch. Let's just see. No, not yet. Okay. I'll let you know if and when she does. I really hope she denies this because what in the hell, right? What in the hell? So, any reference to an investigation, they may not even make a reference to an investigation conducted by Todd Click, but Todd Click's one of their witnesses, along with any reports or investigative materials from Todd Click that's not relevant or is used for the purpose of confusing the issues, or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it's relevant. No, McClellan. The burden is on you to prove your case. And it sounds like you don't have enough evidence to prove your case. So now he's saying the burden is on the opponent to show why it's relevant. Okay, then. So, relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. So just don't bring in any reasonable doubt. Don't confuse the jury. Richard Allen's the guy. He was on the bridge. He said down the hill, and that's it. Even though the timeline doesn't make all that much sense, no matter how many people do visual timelines and graphs and pictures. Sure, okay, it doesn't. It's just to be like, guys, down the hill, and then they go across the water, and that's it. This whole case is like, oh my word. Doesn't it just... It's just insane to me. And especially that he's like, you may not, okay? I mean, Todd Click is a defense witness. What are they thinking? Cook 13 Doodle says, who's silencing who now? I would move house, county, state if I lived there. I know, right? I know. Now they say, any reference, it gets worse. Any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that's not relevant or is for the purpose of confusing the issues or has potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. Wow. Anyway, so number 10, any reference to any prior bad acts. Okay, wait. I got to go back to point number 9. Remember they talked about the geofencing. The defense recently brought it up saying that there were 3 or more. There was like a bunch of cell phones. I think they said 3. 3 or more, as far as I remember. Definitely more than 2. So 3 to 5 is what I remember because I've visualized everything, right? At the crime scene. Cell phones, like not just around, they say at the crime scene. And so now they say you're not allowed to bring any of that in, right? Okay. Hold on, Mr. Grizzly's closing the door. Okay. So they say any reference to geofencing. So they're not allowed to mention any of those words. No testimony from Todd Click. They don't want that to confuse the issue. Any reference to geofencing. Number 10, okay, any reference to any prior bad acts or any acts of any witness that plan to testify at the trial that's not relevant to what the defendant is on trial for. That is not an act that is an exception to IRE 404B, and that is not both relevant under IRE 401 and tend to negate the guilt of the defendant. 11. Any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to the defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. The burden is on the opponent to show why it's relevant. I say again, the burden is on the state to prove their case. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. All I'm hearing is McLean say, don't confuse the issue, okay? The issue is Richard Allen. He's the guy, and that's it, okay? Just guilty, 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 we're done. This is just not how a fair trial works. From everything I know, just from observing. So many trials we've watched together, so many things we've learned along the way, and I'm like, this doesn't seem right. What do you think? Yeah, objection cases, and yet Todd's mental health is relevant. So Nicholas McLean, the state prosecutor, has asked Judge Gull to obtain Todd Click's mental health records and employment records because he wants to basically impeach him, I guess. Impeach that witness, but I don't know if that's the correct term in this scenario from the state, maybe. But he wants to pick apart his credibility. But if that doesn't work, he also doesn't want the defense, in case the judge is like, well, he's going to have to be a witness, okay? He is going to be a witness. Well, then Nicholas McLean says, well, then they're not allowed to talk about him. They're not allowed to talk about him, okay? My goodness. Marie says, gee, guess with your work to bring us the best, no fluff coverage. We will have the shortest trial together. Well, the problem is that Judge Gull has defluffed this trial so much we won't see anything. We won't see anything. We won't hear anything. She has denied all requests for any media coverage. Still photography, video, audio. She's like, deny, 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 deny. So Amy Beck says, this is absolutely disgusting. The Innocence Project will be on this in a heartbeat. I think so too. It's like Stephen Avery all over again. Any reference to how the files were labeled. Now remember from the last documents that we read. If you don't remember, go check it out. Okay, it's all on the playlist. The defense had said, the state it seemed like what they're implying is that the state was trying to confuse them by delaying. Let's say they delayed discovery for months and months and months, even though it's been years that they've had the stuff, right? So they delay things for like 9 months. And then when they eventually hand over some discovery to the defense in little bits, then they confuse it by putting in irrelevant or out of context, not irrelevant, out of context case files in there. Like when they said it seemed like there was video of some guy who looked deceased on a bed being turned over by police. There was also something about a guy in Manatee, Florida, who had blood on his jeans and was being investigated. And that's a whole nother rabbit hole. But they say, why are they including this in the files? So now McLean is like, you may not make any reference to how the files were labeled. Don't tell the jury how I labeled those files, okay? Limit says, I'm so afraid that those poor little girls will not get the justice they deserve. I'm getting very concerned at this point. Same. And thank you for being a member for 12 months. So they say, one more time, 11. Any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it's relevant. Number 12, any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Libby German that are not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury in violation. So must they not bring in the sketches or all the other guys that you said were persons of interest? So none of those. Okay? So any of my presentations would be banned from this trial. It's just like, you may not. You may not talk about any of those PowerPoints. Okay? Right. So they also say that would have the potential to mislead the jury in violation of the rules. The burden is on the opponent to show why it's relevant. Again, I'll just say it again the whole time because I want to say it again the whole time. No. The burden's on you to prove your case. State. And it sounds to me like they're not confident with the case that they have at all. Sandy Hurd said, this case is an episode of Twilight Zone. We've seen shocking twists and turns as well as how the good guys are actually the bad guys and vice versa. I know, right? Thank you so much, Sandy. Now they say evidence may be excluded if it confuses the issues. The only one confusing the issues is the prosecutor, in my opinion. Especially when he's peppering in some other weird, like out of context discovery or evidence, in the case files. I mean, does that mean when they've lost interviews, 70 days worth of very critical interviews from February the 17th, okay, that's not going to confuse the issue. They're like, that's fine. It's not even relevant. But anything the defense wants to say, no, that's just going to confuse the issue. But when we hand over, the state now hands over discovery to the defense, we can just put in other cases there, which makes me wonder if some of those cases have some of the Delphi stuff in it. Are they just mixing up files, or are they purposely trying to confuse the defense? Which, good luck, because they seem very thorough to me. Girls, Nana 2007 says, I lived in that state when this happened. So sad. Oh, I'm so sorry, man. Scott H says, I'm curious about previous trials that Gull and McClelland have worked on. I wonder, have they ever worked on trials together? This is McClelland's very first murder trial. Oh, yes. So, well, that's why I think he's shaking in his boots. Some people say that he's not shaking in his boots. It's very confident. I don't see that. I don't see confidence from any of this whatsoever. I see someone who is crap scared of the opponent, crap scared of YouTubers and deep fakes being created, to the point where Judge Gull is also like, no cameras. Don't worry, McClelland, you've got this. I think he is so scared, in my opinion, from what we're seeing, right? My goodness. So do you guys think that this is going to lead to a fair trial? Do you think so? Now, wherefore the state of Indiana, by prosecuting attorney Nicholas C. McClelland, respectfully requests this court to grant the following relief. A, order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside of the presence of the hearing of the jury. Okay. You will have to go into the chambers and ask Judge Gull, which is why I say mommy, is what it sounds like. McLean is like, you have to ask permission before you or any of your witnesses are allowed to bring up any of this. Wow, okay. And B, to further order said persons to make no reference to the fact that this motion has been filed and granted, and all other relief just and proper in the premises. Wow. The other document that came out today was the state's objection to the defendant's motion to suppress, filed April 15th, which would be when the state requested to suppress all of Richard Allen's self-incriminating statements, is how they worded it, from his police interviews in October of 2022, as well as any of his confessions allegedly made, in the prison and things like that. So he's saying the state's objection to the defendant's motion, which is very obvious that they're going to say that. That one makes sense to me. This motion in limine, so it's like this one's filed and the other one. This one, I understand. The other one, I'm like, what are you doing? Like, that's a little far. Yeah, so I'll just read you the bottom where they said, wherefore the state argues that the encounter between Richard Allen and Lieutenant Holman was a consensual encounter. So he's saying that, remember when Richard Allen, he had two interviews, right? The first one, the state said they don't need to suppress that. It's the second one where they say Richard Allen wasn't read his Miranda rights. They want that whole interview thrown out because it wasn't done right, is what they're saying. McClelland here is arguing why he thinks it's done right. And so they're saying that, wherefore the state argues the encounter between Richard Allen and Lieutenant Holman was consensual. Really? Okay. Thereby making Richard Allen's statements voluntary. Further, if the encounter is considered a custodial interrogation, which the state disputes, Richard Allen was advised of his rights prior to the interview, but they just forgot to record that part. Right. Which he waived by participating in the exchange, despite Lieutenant Holman being confrontational or accusatory or mischaracterizing evidence. So they're like, it's okay. Police are allowed to, we know police are allowed to lie. They're allowed to be deceptive, okay, to get information sometimes. This was more like being deceptive, confrontational, swearing, saying you effing did this and we know it and we know you did something and we're going to prove it. It's a little different than a little bit deceptive, as we've seen in some police interviews, but okay. This also got some type of self-incriminating statement out of Richard Allen, allegedly. We haven't heard what that is. So they say, despite Lieutenant Holman becoming confrontational and accusatory or mischaracterizing evidence. Okay, well, at least that's on paper now. Further, the state argues, not the state, the sate, or the sate. Okay, they just, anyway, argues that the totality of the circumstances supports the conclusion that Richard Allen was not overcome by acts of coercive governmental influences. Wherefore, the state would ask the court to deny the defendant's motion to suppress statements filed on April 15th of 2024 without a hearing and for all other just and proper relief in the circumstances. Pistol Amy, I do not know the answer to that. I don't keep tabs on that. I have no idea. We shall see. I'm still waiting to see if this trial will even happen on May 13th because I don't think it will. I hope it does, I hope it'll be a fair trial. Doesn't sound like it's going to be. But I mean, Judge Gull still has so many things to rule on. We're how many days away now? It's the 29th of April. Days until May 13th, okay, is how many exactly? 14 days? 14 days away. And Judge Gull still has to rule on a number of things, including this over here. I mean, is this going to be granted? Will this be granted where the defense and their witnesses and Richard Allen cannot talk about any of these things? They may not bring up any of this or anything related to it, anything alluding to it. I mean, that just sounds insane to me. I've just never seen this in a trial before. Normally, the state, it's their burden to prove the case. And no matter what crazy crap, it's not usually crap. Sometimes it is though, right? No matter what the defense says, the state, when they're confident in the case, will be like, okay, defense, nice try. You do that, right? So we've often seen also in trials where, or not often, but here and there, more than once, where the defense has nothing to work with. And so they resort to blaming the victims themselves. You know, I mean, this defense, I think they have plausible, reasonable doubt. I think what they've got is very interesting. The fact that the FBI investigated that very same angle is interesting. The fact that Todd Click testified at the March 18th hearing and the transcript from that, very interesting. And now they want to throw that out. I mean, what? Stefan says, slick Nicky uses an electronic signature. Yes, he does indeed. Yes, he does. Doesn't have time to sign these things himself. Just an electronic signature. Quick. Let's just get this out there. Okay. So, I would love to hear your thoughts. Please leave them in the comments below. Also, I don't know if you've seen, but Court TV, it's on courttv.com. It's not sponsored or anything like that. I'm just mentioning it in case you didn't know. They have come out with a documentary on the Delphi case. Okay, how do I say? I'm not shading it at all. I just didn't find anything like riveting or brand new in it. Did you? If you watched it, did you find anything that was like, oh, I did not know that? The only thing that I found quite interesting was, of course, the transitional attorney. I say it like that because it was like, you know, the former attorney was an interim attorney speaking, right, for Richard Allen, one of the defense attorneys. The way he talks about everything, because we got a little bit more information now, you know, that he's like, I truly believe that he's innocent. And he's like, you know, he's not on the case anymore. He doesn't have to say that. He says normally, you know, defense attorneys will say, yes, I believe my client's innocent. But he's like, in this case, I really believe it. And he looks crap scared of the Odinist angle, you know, just he's like, they do exist. And the way he talks about it. And then he also said that the unspent round was found. Now, how many inches? 2 inches. 2 inches. I just want to see in centimeters because I converted it so my brain remembers it. 5 centimeters, 2 inches in the ground. That was interesting as well. When was it found? How was it found? You know, was it a metal detector? Who was it? What's the chain of evidence there? It's very interesting. So if you haven't seen it yet, it is on, I saw now. It was released last night. For me, it was at like 3 a.m, so I did not watch that. That was bedtime. Okay. But I watched it now because they've just put it out now on courttv.com. Yeah. Gisela said they said the unspent round was 2 inches under the ground. Now, some people have said, well, if it's Richard Allen, he could have, of course, stepped on it. Do you know how little they have to work with on an unspent round? I mean, normally if it's a fired bullet, a spent round, the state, let's say, in a case, in a trial, would have quite a lot to work with to say, sure, because of these markings and, you know, all of this, that they've got lots of points of comparison to say it's definitely from this guy's firearm. I mean, from an unspent round to say it definitely came from Richard Allen's gun is going to be really junk science. I mean, as I say, normally with a fired round, already that could be argued in trials that it's junk science, right? Even with all those points to compare. An unspent round? Found 2 inches in the ground? What? And why would he? And I'm just thinking out loud now. Why, if that was Richard Allen there, and it still could be, he's innocent or proven guilty, even if he's the guy, my argument is they botched the case. Things were not done right in this case, you know? But anyway, if he is like cocking his gun there, why would he do it there? Wouldn't he do it along the way or before to try to control the girls, the victims, to get them, you know, to go down the hill, apparently across the creek and end up there? Why would he do it right there and then step on it and put a phone in a shoe under one of the victims' backs? It just is crazy to me. Wow. So one of the theories that, people who investigated the Odinist angle had was that this was, and I think Robert Ives, the former prosecutor, also alluded to something like this. He said there were multiple signatures. So they said it's like a stage, and whoever did this, which is plausibly more than one person, would have wanted to make a statement to scare the community, or a statement to law enforcement or something. We just don't know. It just seems, this case, it's just... I'm going to stop talking now because I've been down so many rabbit holes. And when I saw, and so I need to make sense of it first, make a presentation, and then bring it to you again. Yes, nothing makes sense because it's like nothing makes sense. Literally nothing makes sense. One example, again, when Doug Carter's like, all right, you thought that we wouldn't change our strategy, but now we have, right? And then they release a new sketch. When they release the sketch, in interviews following the sketch releases, which are just of faces, they tell everyone, don't look at the face, don't look at the head, only focus from the head, from the neck down. That's just crazy to me. It's like, this case feels like gaslighting 101. It just feels like, if you want to know what gaslighting feels like, just follow this case, because what is going on here? Yeah, Stefan says, Robert Ives said there were several signatures, which is quite an odd statement, right? Wow. So let's see what happens next. Is Judge Gull going to grant this? Let me just refresh my X over here. X, formerly known as Twitter. Let's just see. Latest. Okay, people are reposting yes, what I posted, because I'm like, this is insane. I'm just like ranting on X. So if you follow me there, my handle's at True Crime Gisela, and I'm just like, what is this? So thank you for being here with me as we explore this new document and Nicholas McClelland's bombastic requests to the judge. I really hope she doesn't just like have her muscle memory of just granted. You're gonna grant that? They're not allowed to talk about any of that. That's just crazy, man. Okay, so Phoebe says, okay, Gisela, got the Grizzly shovel ready. You've been digging a lot, and I know you're not done. Dig me out of this rabbit hole. Okay, so very concerned. 14 days to trial. Doesn't that feel like insanely close? By the time you blink, it's there already, okay? May 13th. What? No transparency, no cameras, no audio, no still photography. Secret. So if anyone lives there and you're going there, yeah, I want your crib notes. Yes, please. We need to know what's going on there. So I'll keep you posted, maybe with a YouTube short, maybe on the community tab. So make sure you look at those things as well. Because, for example, if Judge Gull just says granted and it's just a one-liner, I'll probably make a YouTube short or update you on the community tab. One or the other or both. So check there, because I'm waiting. I'm refreshing the whole time to see, oh my word, is Judge Gull going to grant this? I will be shocked. I will be. Okay. Right. Tiff Knox says, Gull's muscle memory denied. Yeah, denied. So thank you so much. I'll see you all again very soon. There is a trial that I'm so hoping to cover. You've already probably seen my stream that's set up for it. Unfortunately, today they showed opening statements. Only one news channel covered it. It's a different one to the original trial. It's Gurpreet Singh's retrial. Quadruple homicide case, death penalty case, bench trial. I'm like, this is incredible. I really hope they stream it all. After opening statements, as soon as the first witness took the stand, he said about 2 words, and then they said, whoa, okay, we're going to take a 10 to 15 minute break. And then the judges said, the 3-panel judge, they're going to go and view the scene. So I'm like, okay. So they said they're going to take like, an hour and a half to 2 hours and then come back. So I'm monitoring that, okay? So if you see another stream that's already set up, just know I'm monitoring the situation. I don't know if I can proceed with it or not. It depends if they actually cover the full trial or not. If they do, of course, I'd love to watch that with you. Thank you so much, everyone. I really appreciate it. I hope that Richard Allen stays alive until trial and especially after trial, depending on what happens. Good luck to 12 people convicting him. 12 people agreeing. If we had to pick 12 people out of this crowd here, do you think everyone will agree on what? Well, maybe we'll all think this is crazy. This is going to be a tough trial, right? From whatever's going on. And then I think the defense has set up some excellent grounds for appeal because there are many. So Thank you so much. Crime Curious is looking forward to your coverage of the trial. Keep up the great work, G. Thank you so much, and thanks for saying hi. And I will see you all very soon. Bye.